Welcome back to another episode of Spilling Secrets, a podcast on all things related to trade secrets and non-compete law. My name is Dan Levy. I am a partner in Epstein, Becker & Green's Newark, New Jersey office. With me today are two special guests, both joining us from our New York City office. First, a true New York City celebrity and Emmy Award winner, George Whipple.
Nice to be here. And I loved last year's Spilling Secrets podcast, tying movies to the law. And I look forward to this year's.
Great to have you. And also joining us today from New York is a prior guest to the Spilling Secrets podcast, where she participated in one of our most entertaining and informative episodes discussing trade secrets in the world of Harry Potter. Amy Dempsey, welcome back to Spilling Secrets.
I'm glad to be back, and I'm looking forward to spending a little time discussing one of life's great entertainments, the movies, and what we can glean about trade secrets and non-compete law.
Great to have you, Amy. Last year, we launched a Trade Secrets in the Movies episode during Academy Awards season, during which we discussed how trade secrets play out on the big screen. Academy Awards season is upon us again, and so we wanted to bring in George and Amy, both movie buffs, to get their take on trade secrets in the movies. George, why don't you start us off by talking to us about one of your favorite movies and some of the trade secret or non-compete lessons it might have?
Well, one of my favorite movies from this year, which is getting a lot of Academy Award buzz, both for the film itself and the directing, and certainly for the acting, is The Brutalist, starring Adrien Brody. And this is a fascinating film, a very long film, which has an intermission, something I don't remember from the days going back to Barry Lyndon, a movie that has an actual intermission in it. But what is interesting about this is it's the story of a very unique architect and his industrialist, wealthy patron. And the issues that I think are fascinating are, what are the protections for a very creative, unique business, individual, artist, architect, investment bank? And how do you protect those unique assets and those unique ideas? And one of the ways, certainly, to protect them is by trade secret. But when something is as public as architecture, how do you protect intellectual property? How do you protect it from being stolen? How do you protect it from being imitated?
I saw that movie too, George, and as you mentioned, the relationship between the Adrien Brody character and his benefactor was one of the central parts of the movie, and the project suffered from the fact that they didn't have, those kinds of structures and setups in an employee-employer type relationship that some of our listeners might want to pay attention to. There was a big delay in the project when they ran out of funds, and Adrien Brody suffered from the issues that the benefactor ended up having. Isn't that so?
That's absolutely right. There was an issue that faces so many of our clients. Competitors are trying to steal proprietary processes, ideas, and I don't think the character in this movie was particularly adept at protecting his intellectual property. And it was a real lesson, I think, for the viewer as a lawyer to say, gosh, this guy really should have been protecting himself and protecting his trade secrets. And why did he expose himself to his patron, expose himself to his workers, expose himself to his competitors so they could literally steal from him? This is something all of our businesses, our clients, need to focus on. What are you doing every day to protect your proprietary processes, to protect your ideas, so they're not simply stolen from you and replicated at a competitor?
That's fascinating. So I do have one question, and this is for George or Amy. You mentioned that it is, one of the issues was in the public realm of architecture. How can you protect your intellectual property when you have something that is public, but yet the underlying aspects of it are still trade secret or protected intellectual property?
Generally, what I always think about is, what can you keep secret and how do you keep it secret? Just because a bond is being sold on the market doesn't necessarily reveal how that bond is created and the business process that goes into that bond. So the bond itself may be public, maybe in the New York Times, and maybe in the Wall Street Journal. But the process whereby that bond is created, that may not be public. And are we focusing enough on protecting the part of the process and the product that is secret? Because if it is truly confidential, if the process and pieces of the creation of a product are secret, then it is protectable under the law. Amy, what do you think?
Well, George, thank you. I would go with what we tell a lot of our clients as we're beginning to work with them on a project, and that is the planning is critical. Going back to the Brutalist, one of the Adrian Brody architect's issues was that he didn't, going into the project, protect himself from interference by other people that the benefactor wanted to go to. Once the building is built, it has his name on it as the architect, but he was interfered with throughout the design and putting together of the project by another architect that the benefactor went to as more of a bean counter budget guy. Adrian Brody's character didn't go into the project with enough planning to make sure he kept all of the rights from his decisions to himself. Similarly, the benefactor wanted to sort of make this project of love, if you will, and also failed to plan ahead enough for the cost of things and making sure that it would get done in the right way. So we're talking to our clients about protecting their intellectual property, their trade secrets, and going into a big project where the ultimate endpoint is public. It's that planning in advance that's really going to protect them the best.
Isn't one technique, very basic, but very important, getting the right documentation, getting the right contracts in place where people recognize they are being exposed to and working with secret, proprietary, trade secret information, which they cannot disclose or use in the future. This is often overlooked. A very simple thing that you have an acknowledgement and a contract saying that this material is protected.
That's right. There are non-disclosure agreements and clauses that should go into the contracts in advance, and clients need to consider the actual scope of the project and carefully consider all of the aspects of it that might need protection. Not every project is the same. The critical piece is to put that documentation together, make sure that it's understood and signed by anybody who might come across the potential trade secret aspects, and go on from there.
What's important to remember, and I'll touch upon this a little bit when I discuss my movie later on, but it's important to remember that you have to look at this from all angles. It's not just your employees who are going to have access to your trade secrets to develop and market a particular product, but it's also your vendors. And if you're looking to make an acquisition or a divestiture and you're doing due diligence, your third-party vendors and the like, you need to have them enter non-disclosure agreements because they certainly may have access to your trade secrets, and you need to make sure that your intellectual property is guarded in all areas and not just from your internal employees.
I think that's exactly right. The technique of contracting with everybody is one technique. The technique of marking everything confidential, trade secret is another technique. Is it bulletproof? No. You just mark everything trade secret and confidential. Is a court going to say, well, you said it, so it must be true? No. But if you have a contract, if you mark everything confidential, you mark everything trade secret, you keep it locked up at night, you make every effort to keep it secret, then you have a stronger argument when you're before a court that no, this was a trade secret, the vendor stole it, the employee stole it, the competitor stole it, and they should be enjoined from using it.
And with current technology, even employees or vendors can be limited to only seeing exactly what they need to know for their own jobs. A trade secret is not necessarily available to all employees or to all vendors, even if they do sign non-disclosure or confidentiality clauses. It can be more limited, and that will help the arguments in court as well.
And let's talk about a TV show, Severance. In Severance, where people are working exclusively during the day with sort of out any memory or comprehension of the rest of their life, so they're very focused on their work, everyone is doing exactly what Amy suggested, which is they're working in silos and they don't know what the other people are even working on. What better way to protect your trade secrets than having no one know the full process except for the owner or management of the business? It protects them from theft because they can always steal a little piece of it. And it creates a great argument to the court that we protected these trade secrets by only having groups of people work on part of the process, thereby keeping secret, even from our own employees, the other parts of the process. And I think that siloing is a very good technique.
And I think a lot of it goes back to what we've been talking about a few times, which is planning and understanding what the trade secret, why do you have it, and what do you want to do with it? And when you know that and you can plan to protect it, you're going to be better off if someone tries to steal it.
One of the great films this year is The Substance. Now, The Substance is a magical potion that does certain things, but there they protected the trade secret of the substance, which was a chemical that had a reaction in individuals, in the most rigorous way possible, because you had to get the substance through a double-blind secret phone call where you didn't even know who you're talking to on the other side, and pick it up at an undisclosed location, and they didn't reveal to you what was in it. They just gave you instructions on how to use it. That was somebody that was building a bulletproof trade secret defense for the substance. And that was probably the best, although most extreme example of a company trying to protect their proprietary product in the most extreme way possible. But it's a good lesson on the more protections you can put around your secrets, the more likely it is you will be able to protect those in court.
You're absolutely right, George. And the standard under the Defend Trade Secret Act and many of the other state laws is reasonable measures. So you don't have to take all measures, but obviously the more measures you can take and to show the court that you've taken in order to protect your trade secret or your intellectual property from disclosure to third parties, the better you are and the better you're going to appear before the court when you're trying to say there's been a misappropriation of a trade secret. Amy, I know George is a tough act to follow, but now I think would be a good time for you to talk about one of your favorite movies and some of the trade secret or non-compete lessons that we learned from it.
The movie I'd like to talk about is another one that's been nominated this year for several Academy Awards, and that's Wicked. I, for one, am rooting for it to take home several awards. As both of you and many of our audience members know, Wicked is a musical film, and it's an adaptation of the long-running, 20 years now, I think, stage musical, also called Wicked, by Stephen Schwartz and also Winnie Holzman. The movie begins in a familiar place for most moviegoers, in Munchkinland, where the citizens are celebrating the death of the Wicked Witch of the West. In Wicked, Glinda the Good is played by Ariana Grande and is there in Munchkinland when the Munchkins are celebrating. And when a Munchkin child asks her how wickedness happens, she tells the backstory of the Wicked Witch of the West. And that is where the story that the movie tells really begins. For those who haven't seen it, Wicked focuses on the early years of a character named Elphaba Throp, who ultimately becomes known as the Wicked Witch of the West and who is played by the phenomenal Cynthia Erivo. You have to hear her sing. Elphaba is ostracized by society from childhood due to her green skin and her magical abilities, which she can't control and which seem to appear at inopportune times, such as moments of anger. This use of magic is an important component in the trade secrets and non-compete lessons for us from this movie. Much of the movie is set at a place called Shiz University in the land of Oz, where Elphaba goes to Shiz University to see off her younger sister, one of the few people in her life that she is close to. She tries to protect her sister, who is not green and who happens to use a wheelchair, and whose name is Nessa Rose. When Nessa Rose is registering at the university, Elphaba has a moment where she accidentally demonstrates her magical abilities quite powerfully because she feels that Nessa Rose is in some danger. And her demonstration of her magical abilities catches the eye of the dean of sorcery at the school, known as Madame Morrible, who is played wonderfully by Michelle Yeoh. Elphaba sees a chance for herself to get to meet the ruler of Oz if she goes to the university, and he is thought to be quite powerful, and she would like to get rid of her green skin and become like the others and be more accepted. One of the major important plot points is that Elphaba also becomes concerned about the treatment of animals at Shiz University and in Oz more broadly. In the world of Wicked, the animals are quite intelligent and speak just like people do. In fact, one of Elphaba's mentors is an animal who is a professor, voiced by Peter Dinklage. And Elphaba notices a movement among those in Oz to overpower animals and change their rights and stop them from speaking and being equal to humans. So Elphaba takes that on as a cause and decides it's more important to see the ruler of Oz, located in the Emerald City, played by Jeff Goldblum in a delightfully dastardly yet sycophantic turn, to have his help with proper treatment of the animals rather than to remove her green color. The wizard shows Elphaba what could be considered the biggest trade secret in the universe of the movie, known as the Grimmery. It's a spell book in a language that only very few people can read. In fact, Madame Morrible, we learn, and the wizard have been looking for someone who can read the spell book for quite some time. So while the Grimmery is known to contain spells that will do all sorts of magical action, it's of use only to those who can read the special ancient language it is written in. Elphaba is taken to the Grimmery almost immediately after arriving in the Emerald City. And with Madame Morrible and the Wizard of Oz watching, she quickly demonstrates that she can read the spells and operate the magic. While she is demonstrating that she can read this magical spell book, she's tricked into using the Grimmery to cause the wizard's monkey guards to very painfully sprout wings, and then to realize that Madame Morrible and the wizard are actually the ones behind the persecution of the animals taking place throughout Oz that she went to Oz to try to rectify in the first place. In what could be thought of as an epic theft of trade secrets, Elphaba grabs the Grimmery and flees. She is pursued. They try to get her, catch her, and her friend Galinda, meanwhile, tries to convince her to stay at the Emerald City, stay in Oz, reconcile with Madame Morrible and the wizard, and to work with them. In other words, to work with the company and within the system to get what she wants. She refuses, and then with what can only be considered a show-stopping rendition of the song Defying Gravity, this is a musical after all, she flies west with the Grimmery. How does that help us with trade secrets and non-compete? The primary themes of the movie concern friendship and making difficult decisions and power and whether to try to change things from outside or from within. It's not hard to figure out who to root for here, and it's not Madame Morrible or the wizard. However, even if we are not on their side, there are some trade secrets and non-compete lessons to consider. First, the Emerald City harbored this trade secret, the Grimmery, of great potential, perhaps, but Madame Morrible and the wizard were not able to take any economic value from it without someone who understood it and how to use it. So when we were talking about silos a few minutes ago, that can be a really good way to protect trade secrets, but the protector of the secrets needs to make sure that the employees are well matched to the trade secrets or portions thereof that they're working with so that the best economic value can be derived for the business from them. So it reminds us that trade secrets go hand in hand with personnel or employees and their training. So not only should they be well matched, they should be well trained in their use of company trade secrets or even the understanding of them in order for the trade secrets to have the actual value that the company would like to see. Another important lesson is that the employees or users of the trade secrets should be on board in some way with the mission of the company. Sometimes a paycheck is enough. Alphabet took the Grimoire because she vehemently disagreed with how it was being used. Now, most employers' trade secrets don't contain such political drama, but a protector of trade secrets is wise to make sure it understands the market or potential for employees to want to go elsewhere with trade secrets in hand. So that could be likened to a business who has something valuable and even unique in the market, but doesn't perhaps compensate in one way or another its employees well enough to deter them from trying to do better elsewhere and take the trade secrets to the market. In addition, Alphabet can be viewed as a person or potentially analogous to an employee with unique abilities, since she has these special magical skills, and therefore more vulnerable than others perhaps, to moving elsewhere at a higher price. And employees like that sometimes need special handling.
Thanks, Amy. That's a great take on how trade secrets play out in Wicked, one of the best musicals of all time. I do have a question for you. If the Emerald City, whether it be the Wizard or Madame Morrible, chose to take any legal action, what might they be able to do?
Well, assuming that it was a world similar to ours, they might want to seek a temporary restraining order, or TRO, or a preliminary injunction, or could even bring a criminal action. Certainly the actual theft of an object, the object was the Grimoire, could be a crime, depending on the laws in Oz, of course. And a TRO might protect the Grimoire from being used outside the Emerald City. However, much of their success in such a lawsuit would depend on, first, whether they can even show ownership. Certainly they had possession, but the ownership is not clear from the facts in the movie. And they also, as we were discussing before, would need to show the steps they used to protect the Grimoire. Now, in the movie, they had it in a secret room with restricted access and didn't tell very many people about it at all. In fact, Oz had some rumors about it, but a lot of people weren't sure of its existence. And all of those facts would go a long way in their favor, showing that they protected the trade secret as well as they could. However, injunctive relief is an equitable measure as well. And considering the actions of Madame Morrible and the Wizard, in other words, the Wizard fraudulently presenting himself as magical when he wasn't, trying to persecute animals, Elphaba could have a good unclean hands defense to their attempt to get a TRO or preliminary injunction. And she could also argue that while she took possession of the spellbook, she wasn't using it and would not be using it for her own economic advantage or that of a competitor, which is one of the things they would need to show. They would need to show that the economic advantage could be used against them in getting a TRO or preliminary injunction.
I think the TRO hearing and preliminary injunction hearing in that case would be really compelling. Maybe that'll be part 2, but I doubt it.
Perhaps. And hopefully they would have great songs as well.
Yes, that I'm sure of. For my part, I'm going to discuss one of my favorite movies. It is not up for an Academy Award this year because it came out in 1971, but it remains one of my favorite movies that I will watch anytime I see it on TV. And that's the original Willy Wonka and the Chocolate Factory. The first time I saw it, I was enamored by Mr. Wonka in his purple coat and his large yellow bow tie. The movie combined interesting characters, candy, golden tickets, a chocolate river, and most important, Oompa Loompas. As I got older, I realized that it was not just a movie about a candy factory, but one that focuses on the importance of a company taking measures to protect its goodwill and intellectual property. For those of you who haven't seen it, it's about Willy Wonka's efforts to find a successor to his company. Instead of simply seeking a buyer who may not follow Mr. Wonka's vision and enthusiasm for the company, he instead runs a contest where he hides 5 golden tickets and chocolate bars with the hopes that a child will find a golden ticket and prove himself or herself as a loyal and worthy successor to Mr. Wonka. Now, as luck would have it, all of the golden tickets are found by children, including the last one being found by the main character, Charlie Bucket. The winners of the golden ticket are told that their reward could be a lifetime supply of chocolate, but they are also secretly being tested by Mr. Wonka to see if they meet his standards to be the next owner. In the movie, each time a child finds a golden ticket, they are met by Slugworth, who is considered to be the head of Willy Wonka's competitor, Slugworth Chocolates Incorporated, and incentivizes each child to obtain a prototype of the newly invented but not yet released everlasting gobstopper, so that it can be given to Slugworth so he can plagiarize the formula. The movie suggests that Slugworth intends to pay insiders who can infiltrate Mr. Wonka's chocolate factory to help him steal the intellectual property and recipes with the purpose of developing a competing product, but of course without having to spend all of the R&D costs on developing the product himself. The movie highlights some of the measures Mr. Wonka takes to protect his IP. First, before any of the children or their chaperones can commence a tour of the chocolate factory, they are required to sign a non-disclosure agreement, as we discussed the importance earlier on. Mr. Wonka makes very clear to the parents who balk at signing that if the agreement is not signed, they are not allowed in the factory. Second, we learn that Mr. Wonka had to fire all of his previous employees because of the threat that they were insider spies for rival chocolate companies who were stealing Mr. Wonka's trade secrets. The newly introduced Oompa Loompas are the only employees at the company because they are the only ones Mr. Wonka can trust. What trade secret lessons can we learn from Willy Wonka and the Chocolate Factory? First, the movie teaches that a company needs to take measures to protect your trade secrets. As we previously discussed, Mr. Wonka did this by requiring the visitors to sign the NDA, and we can separately discuss the enforceability of the agreement with children, but the point is that Mr. Wonka intended to protect his IP by having potential subsequent owners and visitors sign an NDA before getting access to the company's trade secrets. The same should be true for companies, whether you are hiring a new employee or engaging in due diligence for a potential divestiture or sale. You want to make sure that they sign confidentiality agreements that prevent the disclosure or use of any confidential information except for the benefit of the company itself. Second, you need to understand that there may be incentives out there for employees to misappropriate your intellectual property. These incentives are always present, but are at the highest when the employee is preparing to leave. Mr. Wonka understood that Slugworth and his competitors likely had incentivized Wonka's former employees to misappropriate his trade secrets. And Mr. Wonka addressed this by firing all of his employees and hiring only Oompa Loompas, who are the most faithful employees. Now, this is an extreme example, but it teaches an important lesson that employers can and should take proactive steps to protect their intellectual property. In addition to requiring the NDAs, employers should implement policies aimed at protecting their confidential information, require that employees complete training on those policies on a regular basis, ensure that access to trade secrets are limited to a need-to-know basis or the silos that we discussed earlier, and I would suggest password protections. Now, musical passwords, as in Willy Wonka, aren't necessary, but I suppose you could use those as well. Employers should also consider implementing data loss prevention tools that alert the employer if an employee is engaging in disloyal behavior, such as transferring files to a personal email account or a storage device. And of course, using a DLP tool or application is not enough. The employer actually has to monitor it. Now, I do want to include a note about the ending of Willy Wonka. Wonka initially refuses to give the company to Charlie because Charlie and his grandfather had drank fizzy lifting drink. Charlie's grandfather suggests that Charlie hand over to Slugworth the prototype of the everlasting gobstopper, but Charlie refuses and gives it back to Mr. Wonka. That is when Mr. Wonka reveals that Slugworth is actually an employee of his, and Mr. Wonka used Slugworth to test Charlie's loyalty. Charlie then gets the factory because he passed the test of loyalty by refusing to give the prototype to Slugworth.
That's great, Dan. Willy Wonka is a prototypical movie showing intellectual property concerns. Now, you mentioned that companies should take proactive steps to protect their intellectual property. What can they do?
Sure. So I think we touched upon many of the items in this discussion through Wicked and the Brutalist and my discussion of Charlie and the Chocolate Factory. But Really, the best thing to do is undergo what I call a trade secret assessment or a trade secret tune-up. And what that is a holistic approach that looks at all of the company's measures and systems, including their agreements, their policies and procedures related to confidential information, security measures, HR procedures, including exit interviews, their information security procedures, the use and monitoring of DLP, all to ensure that they are taking all the appropriate measures to ensure that a disloyal employee does not leave with their intellectual property, or even if it's not a disloyal employee, someone who accidentally makes a misappropriation or transfers property that they were not intending to do. All of that review in a trade secret tune-up will improve upon the company's system so they can detect and quickly respond if there is an incident. So thanks, George and Amy. This has been a lot of fun, really good to talk about these movies and the trade secret implications. I look forward to our future conversations about movies and pop culture, including today's cinematic characters such as Munchkins and Oompa Loompas, but of course, trade secrets and non-competes.
It's been a pleasure.
It's been a pleasure. And with all the talk of trade secrets in movies, I'd like to give a shout out to the protectors of the Oscars' big secrets. That is, the winners of each of the Academy Awards. If the Academy and PricewaterhouseCoopers did not do such a good job of protecting those secrets, the countless Oscar pools throughout the country would not be as much fun, and there would be fewer genuine shocked looks to be able to be captured by the cameras for the broadcast.
That's probably the best trade secret kept in America.
I mean, it's been years and years, and you really don't find out ahead of time.
Great. That's absolutely true. And that's a great point, Amy. George, any closing thoughts?
No, I go watch those movies. The Oscars are coming, and look for legal issues. We're all good issue spotters, so let's spot them in the flicks.
Thanks again, George and Amy. A special thank you to our listeners. If you would like to subscribe to the show for free, please go to ebglaw.com/subscribe and click the box for Trade Secrets and Non-Competes /Spilling Secrets podcast series. Thanks again for joining. Until our next episode, this is Dan Levy signing off on behalf of the Spilling Secrets team.
This podcast is presented by Epstein, Becker, and Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.